Okay, so we're going to go ahead and get started. Welcome and good morning to everyone, and thank you so much for joining us for what we hope will be an informative presentation for landlords in the city of Richmond. My name is Palomar Sanchez, and I'm a staff attorney and public information unit supervisor for the City of Richmond Rent Program. Housing counselor Magali Chavez will be conducting this morning's presentation. Please note that this presentation has been posted on the website at richmondrent.org/workshops for your reference. If you have questions on a particular topic discussed today, we ask that you save and propose your questions during our question and answer period at the end of the presentation. So without further ado, I present to you Magali Chavez.
Hello, good morning, everyone. Thank you for joining us. My name is Magali Chavez. I am an analyst with the Rent Program, also known as a housing counselor. So let's go ahead and get started. Before we begin with the actual presentation, we just wanted to give an important community update on the order. So as many of you know, the City of Richmond currently has an emergency order in place. So the emergency order initially went into effect March 17th of 2020 at the inception or the beginning of the pandemic in the Bay Area. More recently, on July 14th, the city manager in her role as Director of Emergency Services passed a fourth supplemental order, which states that no landlord may terminate a residential or commercial tenancy for non-payment of rent or for any no-fault evictions. These are owner move-in, withdrawal from the rental market, substantial repairs, or temporary termination of tenancy. In addition, the order has been extended until the City Council takes action to extend the order to a certain date, or terminates the order, or declines to extend the order. So as of right now, the order does not have an end date until City Council takes action. In addition to prohibiting evictions or certain types of evictions, the order also prohibits any residential rent increases for rent control properties. This includes light-tech properties, or what are known as affordable housing units. Some exception to the rent increase prohibition include properties such as single-family homes, condominiums, new construction property, which is property that was built after February 1st, 1995, and any other property that which rent cannot be regulated under state or federal law. Landlords may also not charge any late fees or require documentation to prove financial hardship from the tenant. If you have any questions or would like to read the order itself, I recommend that you go to the website, www.richmondrent.org. Our website is constantly updating any information, so you can get the most up-to-date information there. With that being said, if you have any questions, please feel free to ask them at the end. At the end, we'll have a Q&A section for everyone to answer questions. So let's get started with the actual presentation. So the topics that we'll cover today is really the purpose of the ordinance, a quick overview of the ordinance, the properties that are covered under the rent ordinance and how they're impacted. Not all properties are covered in the same way. For landlords, this is important: compliance with the enrollment, registration, and fee payment requirements to be in compliance with the rent program, just cause for eviction, and eviction noticing requirements. We'll also discuss aspects of rent control, so the maximum allowable rent, you'll hear it be referred to as a MAR, rent increase noticing requirements, although those are currently impacted by the emergency order. We'll also discuss when rents can be raised to market, the rent adjustment petition process, and we'll touch on some important California law. So what is the purpose of the rent ordinance? Why did this go into effect? So the official name is the Richmond Fair Rent, Just Cause for Eviction, and Homeowner Protection Ordinance, which we'll refer to as the rent ordinance. Its goal is to promote neighborhood and community stability, healthy housing, and affordability to renters in the city of Richmond by controlling excessive rent increases and arbitrary evictions to the greatest extent allowable under California law, while also ensuring landlords receive a fair return the same way under the ordinance and through our petition process. So a quick timeline of the Richmond Rent Ordinance. It was passed on November 8th, 2016 by Richmond voters. It went into effect in December 30th of 2016, and on January 3rd of 2017, the rent program opened its doors to the community. So the Richmond Rent Ordinance breaks up into two sections. The first section is rent control. So what this means is that rents are regulated by the MAR, which is a maximum allowable rent, and it's calculated by taking the base rent, which is the rent that was in effect on July 21st, 2015. If the tenant moved in after July 21st, 2015, it's the first rent that the tenant paid. The second is the annual general adjustment, which is a cost of living increase, also known as the inflation rate in the Bay Area. And the third aspect is a petition process, which is a mechanism that controls it's a mechanism which we increase or decrease the MAR based on reasons permitted under the ordinance. The petition process itself is overseen by a hearing examiner, somewhat like a judge. The second part of the ordinance is just cause for eviction protections. So the ordinance itself breaks down into rent control and eviction protections. And what this means is that a landlord needs to have one of the 8 just causes to terminate tenancy. We'll be going over both of these sections in detail, but the 8 just causes are failure to pay rent, breach of the lease, nuisance, failure to give access. These first 4 are what are called at-fault evictions, meaning that the tenant is doing something to produce an eviction, and then the other 4 are no-fault evictions, meaning that the tenant is doing everything right, but for the very specific reasons of temporarily vacate to do substantial repairs, owner move-in, withdraw from the rental market, or temporary tenancy, the owner can take possession of the property under those just causes. So let's move forward. So like I mentioned before, not all properties are covered the same way under the ordinance. So which properties are covered by the rent ordinance? The first one are what are called fully covered properties. And these are properties that have rent control and just cause for eviction protections, which are multi-unit properties that are built on or before February 1st, 1995. So it's important to ask yourself, if you have a property, how many dwelling units are on this parcel? How many living units are in this property, and when were they built? The second are partially covered properties, which means that they only have just cause for eviction protections. They are not rent controlled by the rent program at all. There might be other laws that impact them, but they won't be rent controlled by the rent program. These are subsidized units, which include Section 8 tenancies. So for example, Section 8 might control the rent under the housing authority, but the rent program will not get involved or will not double regulate. They are also properties with one dwelling unit on one parcel, so what people like to refer to as single family homes. Condominiums or new construction, which is property that was built after February 1st, 1995. Then there are fully exempt properties, which means that they have no rent control and no just cause for eviction protections, which means that the Richmond Rent Ordinance does not apply to them at all, and these properties will have no interaction with the rent program. And these are properties where the landlord and tenant share a kitchen and or bath. So if I am a homeowner and I decide to rent out a room in my house and I live in the property and the tenant and I share a kitchen or bath, then you would be fully exempt from the ordinance. Then there are single family homes where a permitted ADU was added and the main house is owner occupied. An important detail of this is that it's a permitted ADU, so that is permitted by building and planning, and there's the proper documents. There's a lot of unpermitted units in the city of Richmond, and so that impacts where it falls under the protections of the ordinance or enforcement of the ordinance. And then the other one is retirement homes, so nursing homes, most likely. Okay, great. So that is what the properties that are covered under the ordinance. This is just an infographic for accessory dwelling units. I'm not going to go into it in detail, but this is just for landlords to have and to understand how the ADU can impact your property. So if you have an additional dwelling unit on the property and you consider your property a single family home, that might, I mean, it's still a single family home, but it might not be exempt from rent control, because once the ADU is added, and especially if it's not permitted, it can impact how it falls under the ordinance. So if you have an ADU, or if you think you're going to add an ADU, I would recommend that you look over this infographic and look at the different scenarios. So compliance with enrollment, registration, and fee payment requirements, these are very important, particularly for landlords. So we have enrollment and tenancy registration, and then we have the rental housing fee. And if once you start renting out property, or when you add a property, you're thinking becoming a landlord in Richmond, these are the most basic requirements that you have with the rent program to be in compliance. So the first is a property enrollment requirements. So all rental units covered by the rent ordinance are required to enroll their property with the rent program. As you can see, it provides general information about the property, about the owner, where to contact you. Yes, so where to contact you, and if you have a property manager, you would add the property manager to this list, and say that this property manager can manage my property on my behalf, and sign it. So this is just saying I am a rental, I am enrolled with the rent program, and that is one of the compliance mechanisms. If you are a rent controlled unit, then you would be required to do a tenancy registration. So the tenancy registration provides information on the tenancy itself. So it's going to ask you information on the rental property, but it's also going to ask you information on the tenants. When did they move in? How much rent are they paying? What services do you provide in their tenancy? Questions like that. And this information is usually taken from the information of the lease, and it's also the responsibility of the landlord to fill out and submit with the rent programs if you're a rent controlled unit. If you want to obtain any of these documents, as you can see, the links are at the bottom of the slide, so you can go to our enrollment page on our website. So why do we have enrollment and tenancy registration? I know as a landlord, you might think it's tedious, and as a rent program, we have to process thousands of these. So it's definitely not a fun thing. So why do we have it? And the reason is because it's very important to ensure the compliance of the rent program. So there are 4 main reasons, right? So one, it increases compliance. By submitting the information about rent and housing services, it improves compliance with the rent ordinance. By the rent program understands what are the lawful rent levels. It provides more transparency between landlord and tenant, especially for rent controlled units, as registration is required for each new tenancy. It also supports the rent adjustment petition process, so we'll discuss this in further detail in further slides. But the tenancy registration provides a hearing examiner with data on lawful maximum allowable rent, so the MAR for units, understanding rent adjustments, so if the owner files an MNOI petition, it just provides additional information of the tenancy. It also bolsters outreach opportunities. So in the near future, tenants and landlords will receive an annual notice of maximum allowable rents and a guide to rent control in Richmond. So it will inform them of vital information about their rights and responsibilities. So the idea is that the landlord submits the tenancy registration from the base rent that was submitted in the tenancy registration. The rent program can calculate the maximum allowable rent and send a letter to both landlord and tenant being like, hey, based on the information that was submitted, this is what your maximum allowable rent should be. It also improves the fee study and billing accuracy. So like I mentioned before, the enrollment requires for you to have your name, the owner's contact information, and the tenancy registration provides additional information for the tenancy. So it lets us know how many rental units are in the city of Richmond. It also gives us with the most up-to-date information of where and who to contact. If it's you, if it's the owner, if you have a property manager, to contact the property manager. So it's pretty important to make sure you enroll your property, and if it's rent control, to have a tenancy registration. And plus it's required for you to be in compliance with the rent program. In addition to the enrollment and tenancy registration, another requirement is a residential rental housing fee. So the rent ordinance requires the city council to adopt a residential rental housing fee, which is followed by the recommendation from the rent board. In essence, the residential rental housing fee funds the administration of the rent program. The rent program doesn't take money from the general fund. The rent program is funded by the administrative fees that are collected from rental units from landlords. So the most recent fees have been approved for the fiscal year 2020 to 2021. Fully covered rental units will pay $219 per unit, and then partially covered rental units will pay $124 per unit. And then you can see the fees for the previous years. But moving forward, we're already in the new fiscal year starting July 1st. This will be the payment. Okay, great. So those are the compliance mechanisms. So this first section is really about compliance with enrollment and registration and the housing fee. Moving forward, we're getting into the aspects of the Richmond rent ordinance. So what are the compliance with just cause for eviction requirements? So we have just cause for eviction, but we also have noticing requirements. And then we'll also go over the eviction process in a brief overview, just to kind of cement everything and see how everything plays into each other. So, like I mentioned before, the rent ordinance has just cause for eviction requirements. What this essentially means is that if an owner wants to evict a tenant, they need to have just cause. That's, I think, the most simple way to put it. If they in any sense want to evict the tenant, they need to have just cause. And there are 8 just causes, right? So failure to pay rent, it's that the tenant hasn't paid rent and afterwards you've provided the tenant with a 3-day notice to pay rent or quit. So then there's breach of the lease, meaning if the tenant continues to violate written terms in your lease. So for this to be enforceable, right, you would need to have a written out lease. Then there's nuisance. The tenant continues to create a nuisance on the property after a written warning notice has been given. There's failure to give access. So if the owner is trying to get in based on Civil Code 1954, which is lawful landlord entry, and the tenant continues to not provide access, then that could be a just cause. So these first 4, like I mentioned before, are what are called at-fault evictions, meaning that the tenant is doing something to produce an eviction. Then there are no-fault evictions. So temporarily vacate in order to undertake substantial repairs. So that means that the tenant cannot be in the property and the owner can no longer live in the property because the owner wants to do or needs to do substantial repairs. Sometimes it's based on a health order, sometimes an inspector comes in, or sometimes the tenant's like there's mold. But the idea is that the tenant cannot be in the unit and they need to temporarily vacate. Then there's owner move-in, which is that the owner or a qualified relative is going to take possession of the unit to live in it themselves. And they want to take possession and evict the tenant. Then there is withdraw from the rental market. So this is known as the Ellis Act under the state of California. And essentially what this means is that the owner no longer wants to be in the rental business. So they're saying, I no longer want to rent my property. I want to be out of the rental business. And in consequence of them not being in the rental business, it evicts the tenant. The withdrawal from the rental market is highly regulated. And so there's a lot of requirements. And then there's temporary tenancy. Under the ordinance, if I am a homeowner and I live in a partially covered property, meaning that it wouldn't be under rent control, and I decide to leave, if I want to go on vacation or if I, get a temporary job somewhere else, and it's my primary residence, I can rent out the unit for less than 12 months. And then when I come back, temporary tenancy will be my just cause. So I wouldn't have to pay the tenant any relocation payments. It's not that simple. You would need to enroll the property with the rent program. You would need to enroll the tenancy with the rent program. And in the lease, it would need to clarify that it's temporary tenancy. One additional thing is, as you can see, temporarily vacate in order to undertake substantial repairs, owner move-in, or withdraw from the rental market have an asterisk next to it, which just means that a relocation payment is required. The sums are different for all of these, but there is a relocation payment that's required that's given to the tenant which essentially is, hey, I'm evicting you at no fault of your own, and this relocation payment is going to pay for you to move somewhere else. So the sums are different for each one, and it depends on several factors. But if you're thinking of doing one of these evictions, I would recommend you look at the fees. They're also on our website. Okay, so that's just cost for eviction. Moving forward, I mentioned what's called a written warning notice. So breach of lease, nuisance, and failure to give access require a written warning notice. And what this essentially means is that prior to serving the tenant with the termination of tenancy notice, you first have to notify them, saying like, hey, if this is a written warning notice, kind of bringing attention and notification to your behavior. If you don't stop this behavior, it can lead to eviction proceedings. So the notice has to begin prior to a termination of tenancy if the just cause is for breach of lease, nuisance, and failure to give access. And there are several requirements that the notice has to follow. One, it must provide the tenant with a reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate tenancy. Two, it must state that failure to cure may result in eviction. Three, it must inform the tenant of the right to request a reasonable accommodation. Four, it will include the contact number for the rent program. Five, it'll include instructions for compliance. So what steps does the tenant need to take to cure the violation? And six, include information necessary to determine the time, date, place, witnesses present, and other circumstances. So if you have pictures, you can add them to the written warning notice, or if other tenants have been complaining about that tenant, you can attach those complaints. So just documentation. How do you know that this tenant is doing this? And you can see the template is available on our website. The link is at the bottom of the page, of the slide. Okay, great. So let's move forward. So in addition to having eviction, once you serve the tenant with the notice to terminate tenancy, there are requirements that you have with the rent program required by the rent ordinance. So once you serve the tenant with the termination of tenancy, the landlord must submit a copy of the termination of tenancy that was served to the tenant within 2 business days of serving the tenant, along with proof of service. So this is very important. Then the termination of tenancy should be submitted on our website. So the link is provided. For properties with 5 or fewer units, the landlord may submit the notice by mail. Failure to file the termination of tenancy notice in a timely manner may be asserted by the tenant as an affirmative defense in unlawful detainer process or in the eviction process. So if you go to court and you didn't submit the notice with the rent program properly, that is a defense that the tenant can bring up in court. The same thing with not being in compliance with enrollment and tenancy registration, or not paying your residential rental housing fee. All of these things can be used as a defense in court. Okay, great. So I think this wraps up our just cause for eviction requirements and noticing requirements. Like I said, this is just kind of like a brief overview. I know it can be really overwhelming, but this is just, I get a lot of questions from landlords on how the eviction process works. So the first one is tenant fails to pay rent. And then the second step, as you can see, is in the dark blue box. The landlord serves the tenant with the notice to pay rent or quit. Then the landlord must file a copy of the notice with the rent board within 2 business days of serving the tenant. Failure to do so is a defense to an eviction lawsuit. So this is a process. The difference in color for these dark squares is that the dark blue ones are the requirements with the rent program. Everything else in light blue is the requirements with the court. So I think that's the difference in color, is the important distinction. That failure to pay rent, once the rent ordinance went into effect, the only thing that it changed was that now owners have to notify the rent program or submit the termination of tenancy notice with the proof of service within 2 business days. Everything else is in the courts. So once the tenant fails to pay rent within the noticing period of the termination of tenancy notice, the landlord has to file an eviction with the courts. There are two alternatives. One, the tenant must respond with an affirmative defense to an eviction lawsuit. Usually it's 5 days. Right now, there's different state law changes based on the pandemic, but the norm is 5 days, right? And there can be two alternatives. One, the tenant responds with the affirmative defenses and meets the deadline. Then the court mails a notice and there's a hearing date. A judge or jury trial is held, and then there's three outcomes. The tenant wins, the landlord wins, or there's a settlement. If the landlord wins, then the landlord is granted possession. If the tenant does not move out voluntarily, the landlord asks the court to issue a writ of possession, and the sheriff serves tenant with 5-day notice to vacate. Then the sheriff evicts the tenant. Tenant is escorted from the property and may not return. The second alternative is that the tenant doesn't respond, right? The tenant fails to respond within the 5-day deadline. The landlord then files a request for a default judgment. If the judgment is approved, if approved by the judgment is entered against the tenant, and the same thing occurs, right? If the tenant does not move voluntarily, then the sheriff goes and moves him out. So this is a failure to pay rent process. But again, the important thing in terms of the rent program is you would need to notify that, serve that notice, submit that notice to the rent program within 2 business days. So the next slide is the same breakdown. This is just breaking down a different just cause, which is there's a violation of the lease, the breach of lease, or the tenant commits nuisance or fails to give access. The only difference here is that first, the landlord must give the tenant a written notice to cease the violation, which the warning notice must give the tenant a reasonable amount of time to correct of no less than 5 days. If the tenant violates the same or similar provision within 12 months of the first violation, or the tenant doesn't correct it, then no additional warning is required before the landlord can serve a notice to perform or quit. The landlord would then serve the tenant with the notice to perform or quit. Essentially, this is the tenant's second opportunity, right? The first opportunity would be when the written warning notice was issued. The second opportunity is when a notice to perform or quit is issued. At the point that you serve the tenant with the notice to perform or quit, the owner would need, or the landlord would need to submit the notice to perform or quit with the rent program within 2 business days, along with the written warning notice that was initially given to the tenant and proof of service. So that's the process for breach of lease. I'm not going to go into the court process again. If the tenant doesn't comply, then the next step would be to file, or one of the steps that you can take would be to file an eviction lawsuit, and then would follow the whole court process. And the same distinction is that the dark blue squares are what are the requirements with the rent program, and the light blue squares are what will occur in court. So hopefully that gives you some understanding of the entire process and how the rent program is, or the rent ordinance is tied in through the eviction process and the court process, because essentially the eviction process is a state process enforced by the courts, not enforced by the rent program. Okay, so let's move forward. So the previous few pages were for just cause and compliance mechanisms with the rent program. Essentially, properties that are considered partially covered. Moving forward, all of our mechanisms and all the things that we're going to be discussing are for rent control properties. So multi-unit properties that were built before February 1st, 1995. So everything else that we'll be discussing, with the exception of California state law, would be on rent controlled units. So we'll be discussing compliance with rent control requirements. We'll touch on the MAR, the base rent, the AGA, and rent increase noticing requirements. So the first thing is, what is the MAR? Right, this is a maximum allowable rent, and you'll hear this a lot, and it's because it's a very important concept. it essentially controls the entire rent. So the maximum rent, the MAR is the maximum rent that can be charged for a controlled rental unit. A rent increase cannot exceed the maximum allowable rent, but it can be less. Even if the maximum rent or the MAR is not charged, the maximum allowable rent remains the same. So you can charge lower rent, but your MAR will change as the years progress and you get added AGAs. The landlord may choose to raise the rent to the maximum in accordance with state law and the rent board's banking regulation. And in essence, the MAR equals the base rent plus the annual general adjustment, which is what goes into effect September 1st of every year. And this is the norm. The maximum allowable rent is usually calculated by the base rent and the AGAs. Under some exceptions or some cases, it will also include the individual rent adjustment. So that's if a landlord or a tenant goes through a petition process and this impacts the MAR. But for the most part, most rent controlled units are calculated by taking the base rent and the annual general adjustments. To think of it or simplify it, the maximum allowable rent or MAR is kind of considered the rent ceiling. So think of that as a rent ceiling. Okay, so one thing that occurred when the rent ordinance was passed is that a base rent was established. So in order to calculate the MAR, we need to have a base rent. But if you're not having a new tenancy, or like, how do you do that with old tenancies or tenants that have been there for a long time? So under the rent ordinance, landlords were required to roll back rents to the rent level in effect on July 21st, 2015. Or the initial rent if the tenancy began after that date. So if you were a tenant that had been there when the ordinance passed for several years or some 10, 20 years, your base rent was the rent that you paid on July 21st, 2015. If you moved in after July 21st, 2015, your base rent is the first rent that you paid after July 21st, 2015. So we're going to give a little example of how that works. So let's say I moved in September of 2014. When my tenancy began, my rent was $1,000. In December of 2015, the rent was raised to $1,100. In December 30th of 2016, the rent ordinance went into effect. Now, what happens forward is the ideal situation. It's a landlord that is aware of the rent ordinance, and that as soon as the rent ordinance went into effect, they rolled back the rent. So as you recall, it's like, wait a minute, on July 21st, 2015, the tenant was paying $1,000. So this should be my base rent. So in December 30th of 2016, the rent is rolled back to $1,000. So the landlord for the past year and a half had been collecting $1,100, but it's like, hey, the rent ordinance went into effect. It says that I have to roll back your rent to what you were paying on July 21st, 2015. So as a tenant, my rent is rolled back to $1,000 and my base rent is $1,000. On February of 2016, after proper notice, the landlord increases the rent by the allowed 2016 annual general adjustment of 3%. So my rent goes to $1,030. So that's essentially what the rollback did and how the base rent and annual general adjustments work. One thing to note is that the rent ordinance was not in effect, right, from prior to December 30th of 2016. So any rent that was collected from December 2015 to December 30th or before December 30th of 2016 is not rent that the owner has to give back. But if the owner was collecting excessive rent or rent that was above the base rent after the ordinance went into effect, that would potentially be considered excessive rent, and the tenant would have a right to file a petition because they're collecting rent that's above the MAR. Because in this example, my MAR would be $1,030. And if the owner had never rolled back the rent, they would have been collecting $1,100. So we'll go over that in more detail in the further petitions and throughout the MAR, but that's an important concept. Okay, so touched on the base rent. The other aspect is the annual general adjustment. So what is the AGA and how is it calculated? So the AGA is the annual allowable cost of living increase. It's equal to 100% of the consumer price index, also known as the inflation rate of the Bay Area. It's announced by the rent board no later than June 30th of every year. And when can the first AGA be taken after new tenancy begins? So one full calendar year must expire after September 1st of each year. So for example, we are currently in 2020, July of 2020. So in order for me to qualify for the AGA in September 1st, my tenancy had to have begun prior to September 1st of 2019. Similarly, to qualify for the September 1st, the AGA of September 2019, my tenancy had to have begun prior to September 1st of 2018. So it has to be a full year between September and September. When during the year can the AGA be taken? So the AGA can be taken on September 1st of each year after proper legal notice. So that's Civil Code 827. Can landlords bank AGA increases, or if you don't take the AGA, is it loss? So essentially, the AGA can be banked if you don't apply it. But what occurs is known as this banking regulation. And what this means is that in order to prevent rent shock, a landlord never loses their AGAs if they don't give them or if they don't issue them, but they are limited to how many they can give at once. So the limit is 5% of previously deferred AGAs. So those are how many AGAs you can recover each year, plus the current year's annual general adjustment. But note that rent increases cannot be applied retroactively. If you have questions about this, you can look up Regulation 602. But to give an example of this, let's say an owner never gave an increase since the ordinance went into effect. The tenant is still paying the base rent. The owner will have, I can't think of it off the top of my head, but they'll probably have around 13 to 14%, even probably more, of banked AGAs. So like I said, the owner would never lose them, but the maximum that they could apply at once currently, hypothetically, because the emergency order is in effect, would be, I think it's 8.5%, because it would be yes, it's 8.5%, because it would be 5% of the AGAs that were taken, that were banked before, and then 3.5% of the current AGA. So the 2019 AGA was for 3.5%. Sorry, I had to go forward because I didn't remember the AGA for 2019, but it's 3.5%. So it would be 5% from the banked or deferred AGAs and 3.5% for the current year's AGA. The maximum that they can take would be 8.5%. And the rest of the bank AGAs, they could take it next year because the maximum is within a 12-month period. Okay, I know it's a little complicated. So what are the annual general adjustments from 2016 to 2019, and now there will be one in 2020. So the annual general adjustment in 2016 was 3%, 2017 was 3.4%, 2018 was 3.6%, and 2019 was 3.5%. The 2020 AGA has been recently announced, and it's for 2.9%, and it would be effective September 1st. So on September 1st, the maximum allowable rent would be increased by 2.9%. One important thing to note is that in addition to the requirements of the rent ordinance and rent program, there's also California state law that would apply. So a landlord must give the tenant proper notice of a rent increase per California Civil Code 827. And essentially, if you are giving 10% less than 10%, it's a 30-day notice. If it's more than 10%, it's a 90-day notice. Most rent control units, it would be less than 10% because of the banking regulation. So it would be a 30-day notice. Okay, so this is just an example of the maximum allowable rent of the MAR. So you can see how things increase on a year-to-year basis. The MAR, one thing is that the MAR is compounded, so the AGAs are compounded. So you would multiply, 1,000, the 3.0%, and then the 3.4% would be added to 1,030, not the base rent of 1,000. And similarly, the 3.6% will be added to 1,065.2. So here you can see how the MAR or the MAR increases on a yearly basis as a tenancy continues to qualify for an AGA. So one thing to note is that the MAR will increase automatically, right, as the new tenancy qualifies for a new AGA, but the rent increases are not automatic. The rent increases may only take effect, one, if you qualify for the AGA, right, so if the tenancy was in effect prior to September 1st of the previous year, and after proper notice per Civil Code 827. This is just a visual example of how the MAR works. In addition to all of that, there are also requirements for taking the AGA, and there are administrative requirements and noticing requirements with the rent program and state law. So the administrative requirements with the rent program is one, that the landlord must be in compliance with all aspects of the rent program or the rent ordinance, which is the property enrollment, the tenancy registration, they have to pay the rental housing fee, and also the rents have to be properly rolled back. And if there was any excess rent that was charged to the tenant, that had to have been returned to the tenant. So in order to take any rent increases or in order to do an eviction, it's always recommended that you are in complete compliance, or you should be in complete compliance with the rent program and the rent ordinance, because if you're not, then that's something that could always be challenged. For the evictions, it would be challenged in court. For the rent increases, it would be challenged if the tenant wants to file a petition with the rent program. Then there are the noticing requirements, which I have mentioned, right? You would need to follow Civil Code 827. But in addition to that, you also have to provide the rent program with a copy of the rent increase with proof of service within 10 days of having served the tenant. And another thing is you would also have to give the tenant a brochure with when you give the rent increase. And the quick reminder to this is that only properties that are subject to the rent control provisions of the ordinance are required to file a rent increase notice with the rent program. Properties that are not under rent control, we do not receive any of those noticing requirements and have no requirements with the rent program other than the eviction protections that they would be under. Great. How am I on time? Okay, good. Then another question that we get a lot is, when can rents be raised to market? And there are really three scenarios that this could occur. One is when there is a voluntary vacancy and a new tenancy begins. So I move out of my unit, I leave the unit, and the owner starts a new tenancy and establishes a new base rent and raises the rent to market. The second one is when all of the original occupants or leaseholders vacate and only holdover subtenants remain in the unit, because you did not have because you did not have a direct relationship with them, or they are no longer original occupants. You can say, okay, we're starting a new lease. This is a base rent. And at that point, you can also decide to raise the rent to market or whatever it is that you want to charge. The third is if the tenant no longer lives in the unit as his or her primary residence. So the rent control provisions or rent control benefits are given to people who live in those units as their primary residence. Let's say the leaseholding tenant that used to be their primary residence is no longer living in that unit, and they decide to sublet that unit because it's under rent control. Or they use that unit as their vacation home. If it's kind of like, oh, I come here, few weeks out of the year or something along those lines, but it's no longer their primary residence, but they hold on to the unit because it's under rent control. The owner can file a petition and make the claim. Obviously, the owner will have the responsibility to prove that it is not their primary residence. They would have by a preponderance of the evidence, but there is a mechanism that they could file a petition and say, I should have the right to raise this unit to market because the tenant no longer lives there as a primary residence, or they are subletting this unit to someone else and this is not the original leaseholder. So those are the three options that can allow you to raise the rents to market. So this idea of raising the rent to market when there's a turnover tenancy it comes from Costa-Hawkins Rental Act. And essentially it's based on vacancy decontrol and recontrol, which is an important concept and that controls rent control in California. So essentially the idea is that when the tenancy begins, the property is controlled or recontrolled. So the example here is that in March 2015, the landlord and tenant contract for $1,000 in rent, which garbage, water, and parking is included. So at that point that my tenancy begins and this unit is under rent control, my tenancy has been controlled and my base rent has been established to $1,000, including the services of garbage, water, and parking. My tenancy moves forward. In 2016, the rent increase is for 3.3%. The owner issues that rent increase, so now my rent is $1,030. In 2017, the rent increases by 3.4%, and my rent goes to $1,065 with 2 cents. Then I decide to move out, so a new tenancy begins, or all of the original occupants have vacated. At this point, it's decontrolled, meaning that the owner has a right to raise the rent to market, or that rent control protection is removed from that unit. And so in 2018, a landlord resets the rent to $1,450 and contracts with the new tenant, and then now parking is not included in the lease. So once that decontrol occurs, the landlord can reestablish a new rent, and with that can reestablish a new tenancy and change their terms of their lease. So this is an important concept to understand how vacancy decontrol and recontrol works. Okay, so that wraps up our rent control sections. Another important aspect of the MAR, like I mentioned before, is the rent adjustment petition process. And so there are landlord petitions and there are tenant petitions. But to recap, it's essentially a mechanism to do an increase or a decrease in the MAR, in the maximum allowable rent. So landlords have 3 petitions. The petitions that they have is that they want to increase the MAR due to increases in number of occupants allowed. So like if you have a lease and your initial lease had 2 people, and now the tenant has, asked their friend to move in to help paying the rent, or ask, 2 other people to move in. Let's say they live in 2-bedroom apartment and now there's a couple living there. You can always petition for an increase to the MAR. The regulations allow for up to 15% for every additional person. There is an asterisk sign though next to this petition. And that is because a petition for an increase in the number of occupants will not be approved if it concerns additional tenants pursuant to the regulations of the Richmond Rent Board. So for example, if I'm a couple there and I have a baby, you wouldn't be able to petition for that baby. There are protections under the ordinance and under state and federal law, right, that say you can, petition for an increase in that baby. So there are specific regulations around it. If you think you might be under that scenario, you might want to read the regulations and the ordinance and get in contact with the housing counselor. The second petition is to increase the maximum allowable rent due to increase in space or services. So a good example of that is the example that we saw before, where you established a tenancy, but you didn't include parking. So you established the base rent for $1,450, but the lease did not include parking. And let's say you have a parking space and the tenant says, hey, I just bought a car, I would like to add parking space. So you're saying, okay, well, we can do that, but the parking space is not included in your initial tenancy, so I'm going to charge you $50 or whatever is commercially reasonable for a parking space. And so you would need to file a petition for the additional service, and the hearing examiner will review it and ensure that it is commercially reasonable and approve it. If there are, of course, the tenant and the landlord will need to agree to this additional service. The third one, and the most complex petition for landlords, it's increase in the MAR due to increases in net operating costs. And essentially, this is what the fair return is considered under the ordinance. The petition itself is called, the acronym is MNOI. It's Maintenance of Net Operating Income. And what this is saying is essentially it's comparing the base year of 2015, the net operating income of 2015 to the current year. It works like taxes, so the current year would be 2019. So it's comparing it. It's saying what was the net operating income in 2015 adjusted for inflation. This is by the way, this is a very simple explanation because the MNOI petition is pretty complex. So if you do have questions, I highly recommend that you speak to a housing counselor because this is very simple explanation of the MNOI. But essentially it's saying, what were your net operating incomes in 2015? We're gonna adjust it for inflation, and what are your net operating incomes in 2019? If your net operating income in 2019 is substantially lower than what the 2015 was, that's when the hearing examiner can approve a rent increase. Of course, there's all these regulations and laws that go into it, but that's the very basic idea. So those are the three petitions. Once you file a petition, there are important petition facts, right? The tenant has a right to object to the petition. So it's kind of, the process is an administrative process that's done by the rent program, but it's very similar to court. So the tenant would have the right to object. They can bring forward any documentation. Most petitions will result in a hearing, which is conducted by a hearing examiner. Some petitions may be decided administratively if the party waives their right to a hearing and the facts of the case are straightforward. And then if the hearing examiner issues a decision, that decision could be appealed to the rent board. So these are the landlord rent adjustment petitions. I'll also go over the tenant petitions. So tenants also have a right to petition, and they also have three petitions. The first one is for excessive rent. So the petition is for excessive rent due to failure on behalf of the landlord to roll back the rent. So the owner never fixed back the rent. And that's the example that I gave. And the tenant has been continuously paying excessive rent this whole time. As you can imagine, it's been now 3 years since the ordinance passed, more than 3 years. So that has added up, every month that the tenant has paid excessive rent. Or for charging rent above the maximum allowable rent. So not just the base rent, but let's say 1 year the landlord gave me a $200 increase, and that was way above what the AGA allowed. So those are the scenarios that it allows. One important thing is that for rent controlled units, the security deposit is considered rent. So if there's any discrepancy or any issues with the security deposit, because it's considered rent, the tenant can also file a petition if it's under rent control, if there are issues with the security deposit. The second petition is a petition to reduce the rent due to a decrease in space, services, or habitability. The most common one that I see is habitability. The idea is that the tenant is paying rent for specific space, for specific services, for specific habitability that is awarded to them by state law. So at the point that these things are not being met, they're overpaying in rent, right? The $1,000 that I pay in rent is worth me living in a mold-free unit. At the point that they have mold in their unit, they have a right to petition and say, I think my rent should be less, and I think the rent program should reduce my rent. There's also petitions for space, reduction in space. Similarly, like if my room is covered in mold, I cannot use that room, so there's a reduction in space. The services one, the common one that I see is with parking space. So sometimes the tenant will say, my lease had 2 parking spaces, and now the landlord says I can only use 1. So the tenant can petition, hey, my lease initially included 2, and now the landlord has removed a parking space, and I want the rent to be reduced for the equivalent of that 1 parking space. So those are the examples that I see with that one. Then there's a petition to reduce the rent due to a reduction in number of tenants allowed. So I have actually never seen this petition actually go through. But the idea is that, let's say my lease authorizes 2 people to live in the unit or 3 people to live in the unit. And I live in a 3-bedroom apartment, 3 people live in the unit. One of the tenants moves out, and I tell the owner, like, hey, one of the tenants moved out. The other 2 of us are going to stay in the unit, but we want to replace that tenant, which is allowed under the rent ordinance on a 1-to-1 basis. And the owner says, no, I don't want you to replace that tenant because it's caused more damage. The third person has caused more damage, or for whatever reason, they don't want to replace that tenant. If the landlord unreasonably refuses the tenant to replace that third tenant, which is allowed to them under their lease, the tenant has a right to petition and essentially claim, well, you know, my rent was initially $3,000, and each one of us paid $1,000. Now we have to pay $1,500 because there's only 2 people. The tenant can file a petition for a reduction of the rent and the number of tenants allowed, and it's the percentage of tenants reduced. So if there's a 33% decrease in the number of tenants, because now out of 3 there's only 2, the rent, if the hearing examiner decides, the rent can be reduced by 33%. I've actually never seen that petition personally as a counselor, but that is an option that tenants have. So some important petition facts. Similarly, the landlord would have the right to object. Most petitions will go through the hearing. Some petitions can be discussed administratively, and for either of the decision that's made by the hearing examiner, the tenant or the landlord can appeal the decision, and it would go to the rent board to decide. So those are the rent adjustment petitions. So that covers the entire aspect of the rent program. As you can imagine, there is also important California state law that directly intersects with the ordinance. So that's the law that we'll be going over and touching in detail or going overview. So one of the main laws is the implied warranty of habitability, which is Civil Code 1941.1. And this is the idea that the landlord must provide a property that is in habitable condition and fit to live in. Landlords must repair problems that make the property uninhabitable, except for the problems caused by the tenant or the tenant's guests, children, or pets. But essentially, in order to have a habitable unit, the owner must follow the following things, right? Some of them are gas facilities in good working order, effective waterproofing, floor, stairways, and railings in good repair. You can read over in detail, and we'll touch on it more, but that's essentially the idea. Then there's also the Health and Safety Code 17920.3, and this essentially just provides additional detail and regulation on what is considered a habitable or healthy and safe unit to live in. But essentially is any building or portion of the dwelling unit, guest room, or suite of rooms on the premises on which the same is located, in which there exists any of the following listed conditions to an extent that endangers the life, limb, health, property, safety, or welfare of the public or the occupants thereof, shall be deemed and hereby is declared to be substandard building. So, right, so if there's inadequate sanitation, if there's lack or improper water closet, if there is infestation of insects, vermin, or rodents, lack of required electrical lighting. So there's different 14 things that you can read through that essentially is, if any of these are met, it would be considered a substandard building. So essentially, the implied warranty of habitability is a legal theory, right, which has been developed and defined through various cases. And the California Supreme Court has expressly held that the implied warranty of habitability exists in all residential rental agreements. So this is a right that tenants have. This means that it is a landlord's duty and promise to provide tenants with safe and sanitary housing, as is defined in Civil Code 1941.1 and Health and Safety Code 17920.3 in exchange for collecting rent. So it's part of the lease, it's part of the agreement that you have with the tenant. Similarly, implied in every California lease is also the implied covenant of quiet enjoyment, right? So this is guaranteeing that tenants will be able to peacefully enjoy their homes. So this is Civil Code 1927. This quiet possession includes two requirements. First, the landlord may not take any action that substantially interferes with the tenant's lawful use of their home. Second, the landlord must take action to provide a tenant with the quiet enjoyment or quiet possession of the tenant's home if the landlord is aware that the tenant's lawful use of the property is jeopardized. So those are important state law, and really state law that is continuously intersecting with the ordinance and is part of a lot of the processes that the rent ordinance has, hence the rent adjustment petition process. So then there are tenants' responsibilities. So under state law, there are also responsibilities that tenants have, and this is 1941.2. So a tenant must take reasonable care of the rented property and common areas such as hallways. This means that the tenant must keep those areas in good condition. A tenant must also repair all damage that he or she causes or that is caused by the tenant's guests, children, or pets. This can means keep premises as clean and sanitary as the condition of the premises permits, use and operate the gas and electrical and plumbing fixtures as intended or properly, dispose of trash and garbage in a clean and sanitary manner. Another civil code is Civil Code 1950.5, which is security deposit law. This is a long civil code, so I'm not going to go over it in too much detail, but it's very important. So I would recommend that landlords read it through. We also have a workshop specifically on security deposit law and the civil code, which kind of goes over the steps that a landlord should take and explains has different tips. So you can go on our workshops section and look at the security deposit civil code. But essentially, a definition of the security deposit is any payment, fee, deposit, or charge imposed at the beginning of the tenancy as an advance payment of rent, or to be used for recovering rent defaults, repairing damages caused by the tenant, or cleaning. This does not include the application or the screening fee. The first month's rent isn't considered a security deposit, but any money paid in excess of the first month's rent is considered security deposit. The maximum that a landlord can collect for a security deposit is 2 months rent for an unfurnished unit and 3 months rent for a furnished unit. So the landlord can collect rent defaults, repair damages a tenant or tenant's guest cause, more than normal wear and tear, do necessary cleaning, defined as the amount of cleaning needed to return the unit to the same level of cleanliness at the beginning of the tenancy. So how clean was a unit when you initially gave it to the tenant? Landlords, this is an important one, landlords are obligated to offer a walkthrough inspection at the end of the tenancy, 2 weeks prior to the tenant's vacating. And then when does the security deposit have to be returned to the tenant? So I see this a lot, especially through the petition process. The tenant or the landlord has to return the security deposit within 21 days after the tenant vacates. So this is a very important note, because sometimes landlords don't know this and they take longer than 21 days. And so that can be an issue, right? So once a tenant vacates, make sure you're accounting and documenting if there are any deductions over $125, and make sure that you're providing proper documentation and notifying the tenant of what has been deducted from the security deposit, if anything, and returning that security deposit or the accounting within 21 days. The last thing that I'll touch on is that if a tenant does not receive a refund, or if within 21 days, or if they dispute any claims of the refund with the landlord of the security deposit, they may sue the landlord in small claims court. If they are under rent control, they could file a petition with the rent program. The difference of filing the petition in the small claims court is that the tenant can sue for twice the amount of the deposit for bad faith retention. So that is a key difference from the petition and the courts, the small claims court, but it's an important one, and that's how tenants would enforce their security deposit or any disputes within the security deposit. So moving forward is 1954, which is lawful landlord entry. And like I mentioned before, this is a just cause if the tenant is not abiding by this. So failure to give access is a just cause. But essentially lists out when and how the landlord can enter the property. So the landlord may enter only to make necessary or agreed repairs, decorations, alterations, improvements, or to supply necessary or agreed services, exhibit the dwelling unit to prospective or actual purchasers, mortgagees, tenants, workers, or contractors, or to make an inspection to pursuant to section 1950.5, which is security deposit law that I just mentioned, before the tenancy ends within the 2 weeks. So the landlord must give the tenant a written notice to enter at least 24 hours prior to entry. The landlord does not need to provide written or verbal notice to enter in cases of emergency. One important thing is that the tenant cannot demand that they be there when the landlord enters. So and sometimes that's where tenants get in trouble, because the landlord has provided a 24-hour written notice or saying, hey, I'm entering during the specific date and time, which are under normal business hours. And the tenant will say, actually, I'm working that day, so you can't enter the property and will not provide access. So that is something that I commonly see. So it's important for the tenant to understand that and the landlord to understand what their rights are. Entry must be given during normal business hours. The landlord must state the time and date as well as the purpose of entry in the written notice. And like I said, in Richmond, it is just cause to evict a tenant who denies the landlord lawful entry after the tenant has been warned, because they are required to receive a written warning notice and they continue to deny access. The next civil code is 1946, which is proper notice when terminating tenancies. So for no-fault evictions, landlord must give at least 30 days written notice to terminate a tenancy if the tenancy is less than 1 year. Under the same code, a tenant must give a 30-day notice to vacate and give notice on they can give a notice on any day of the month once the lease has converted to a month-to-month lease. A landlord can require more than 30 days notice if the tenant is on a fixed term lease when they are giving notice to vacate. And then under Civil Code 1946.1, a landlord must give at least 60 days written notice to terminate a tenancy if the tenancy has lasted a year or more. So this is a California state law, but it's important to note that any termination notice served in the city of Richmond must also cite one of the permitted just causes for eviction, unless the rental unit is fully exempt from the rent ordinance. So Civil Code 827, which is given proper notice for changes in terms of tenancy, including rent increases. I've already gone over it, or I mentioned it in different slides. But generally, changes in terms of tenancy require a minimum 30-day written notice. A notice to increase the rent by 10% during any 12-month period or less requires a 30-day written notice of rent increase. So if you're increasing the rent by less than 10%, it's a 30-day notice within any 12-month period. A notice to increase the rent by more than 10% during any 12-month period will require a 90-day written notice of rent increase, which is effective January 1st, 2020. Before January 1st, 2020, it was 60-day notice, but it has changed to a 90-day notice. So that is also an important note. There is 1951.2, which is a lease breaking law. And this essentially is that if a tenant breaks a lease, they are liable for unpaid rent remaining on the lease, but only if one, the landlord attempts to mitigate unpaid rent damages by making a reasonable effort to re-rent the unit, and the unit remains without a sitting tenant, right? So in other words, if the tenant breaks the lease, the landlord cannot make the tenant pay for the remaining unpaid rent unless the landlord can show that they made a reasonable effort to re-rent and were still unable to find a replacement or a new tenant. So the landlord has to make an effort to re-rent the unit out. And then also, once a new tenant occupies a unit, the previous tenant's liability for the rent is over. So if the tenant moved out in the middle of June and they paid for the whole month of June, right? There can't be double dipping, and then another tenant moves in the middle of June. There can't be like a double charge of the rent. And then also, landlords are also capable of breaking the lease. This is a little bit more complicated. This usually relates to habitability issues or peace and enjoyment of the property, right? That the landlord is not maintaining the lease by not providing the tenant habitability issues or other things. There are also additional important codes that sometimes interact with the ordinance or with the lease. So there's Civil Code 1717. The idea is that there's no such thing as a one-way attorney's fee. So sometimes the leases will have attorney's stipulations on attorney's fees, provisions on attorney's fees. If a lease has such a provision, it will be interpreted as applying to all parties in the contract. There's Civil Code 1942.5, which is anti-retaliation state law. This is an important law, and this provides for statutory damages and attorney's fees. There is a case for retaliation. Then there's Civil Code 1947.3, which states that landlords must allow for different forms of payment for rent and deposit besides cash or electronic funds of transfer. And this is usually, in the lease when you have the initial tenancy. So I believe this is the last slide. Thank you so much for joining us and staying through the workshop. Here is the information for the rent program. We're currently working remotely, but of course you can call us or email us or visit our website for any information. Moving forward, we're going to have a Q&A session. If you have any questions, please put your question in the Q&A section and we will answer it accordingly. Thank you.
Thank you so much, Magali.
Great. Thank you, Magali. So we're going to go through the questions in the order that they were received. And so let's get started. So the first question is, what are the, and the first and second questions are very similar, so I'll ask them together. It's basically asking, can you go over the different fees the City of Richmond charges landlords, such as the business license, residential rental housing fee, the rental inspection program, and anything else? Okay, so for landlords, there are 4 different fees. So each agency or each department has their own fee. So the rent program has a residential rental housing fee. And then there is the building and planning. Is that correct? Yeah, there's building and planning, which has the business license.
No, that's finance. Sorry, that's finance.
Which one is building and planning?
The inspection program.
Sorry.
The inspection, yeah.
Building and planning has a residential rental inspection program. So they charge you a fee for signing up for the residential rental inspection program, which is required for most rental units. And then they charge you a fee every 3 years when you re-inspect. Then there's the finance department, which has the business license tax. And this is for any property, any rental property in the City of Richmond, but this tax is per parcel. So if you have a unit that you rent out, and currently there's an exemption if you rent out for less than $600, but the business license tax is for parcel. And then there's a fire prevention services fee, which is with the fire department. And they essentially will also do inspections and charge you a fee for fire prevention for rental units.
And a summary of these fees is available on our website on the fees page.
Yes, if you go to the rent program, we have a section on the left-hand side of the web page I don't know if you mind if me share. I don't know how much you want, how interactive, because I can share it like all on the website. But if you go on our website on the left-hand side, there's all these tabs. And if you go under fees, there'll be a summary and breakdown of all the fees with the city.
Yeah, I think just in the interest of time, we should move on because we have a lot of questions.
Yeah, you're right.
Okay, great. The next question is, and I can answer this one, who approved the increase on the rental housing fee? So the increases on the rental housing fee were recommended to the city council by the rent board, and the city council ultimately approved them in May. June. So that was the city council. In terms of who approved the rental housing program, the rent program was created after Richmond voters passed the rent ordinance. So it was approved by Richmond voters. The next question is, if I don't have a lease with my tenants right now, can I ask them to sign a lease now?
So the answer is, if you want to answer it.
No, go ahead. Go ahead.
So,
go ahead, Magali.
Yeah, the answer is yes. You can ask them to sign a lease if you want to, but be aware that the tenant isn't responsible or required to sign a lease. So currently you would have a verbal agreement. You can ask the tenants to sign a lease, and some tenants prefer to be on a lease. So it depends on a case-by-case basis, but they're not required to sign a lease. And there's no, like, it's not a just cause for eviction if the tenant says, no, I don't want to sign a lease. So your enforcement would be pretty limited.
Great. The next question is, when do landlords have to pay fees, if there are any? So I can take a pass at answering this. As Magali mentioned, there are a number of different fees in the city of Richmond. They're administered by different departments. So it really depends on the department. The business license, for example, it's due every 12 months, and it's based on when you got your initial license. The rental inspection program fees are also on a rolling basis, so there's no one date where everyone's required to pay. It depends on when you, enroll in the program and when you actually get an inspection. The fire prevention services fee is also based on when you got the inspection, so there's no one date for that. And finally, the rental housing fee is due within 35 days of the date on the invoice. Those invoices are typically mailed in August and September. So it depends on when you receive the invoice. The next question is, it would be great to get this flow chart. I think they're referring to the eviction flow chart. So this presentation has been posted at richmondrent.org/workshops. So you can download the presentation, and the flow chart is contained within the presentation. The next question is, what are multi-unit units versus multiple dwellings?
I mean, under the rent ordinance, they would kind of function similarly. So multi-unit properties are usually apartments, right? So that's how they would be described, as multi-unit properties, more than one unit. And the common term or use is apartments. They're multi-unit properties. But under the ordinance, or Costa-Hawkins law, really what is prohibited from being under rent control are properties that are new construction. So if they were built after February 1st, 1995, properties that only have one dwelling unit on the property. I think that's, well, there's others, but the idea for rent control is how many dwelling units are on the property. So this gets talked about a lot, or a lot of it that occurs is for single family homes. So like I said before, there are a lot of unpermitted units in Richmond. So somebody will have a property that they consider a single family home. They have the main house that they rented out, and they add a additional dwelling unit on the property. So now it's a multi-unit property, right? There are multiple dwelling units on that property, meaning more than one. And if they were constructed before February 1st, 1995, or the certificate of occupancy is before February 1st, 1995, they will most likely fall under rent control. Palomar, you might want to add some of the legality of Costa-Hawkins law, but I think essentially they will function very similarly under the ordinance in terms of whether they fall under rent control or not.
Yeah, I think you hit it pretty well. The only thing I would say is that the Costa-Hawkins Rental Housing Act, which has been in effect since 1996, talks more specifically about single units. It talks about a property that is separate and alienable on title. So basically, if you have like two houses on one parcel and you can't sell them separately, then it's actually a duplex, not considered like two single family homes or anything. But that's the only part that I was going to say. Costa-Hawkins has very specific language on that. So if you need to, find that, you can always, just Google Costa-Hawkins Rental Housing Act and it'll come up right away. That's all.
Great, thank you. The next question is, who created the rent ordinance? Why was it created and who approved it? So I can answer this one. The rent ordinance, as I mentioned, was adopted by City of Richmond voters. It cited the purpose of the rent ordinance is to control excessive rent increases and prohibit evictions, arbitrary or discriminatory evictions to the greatest extent allowed under California law. And it was adopted by a majority of Richmond voters in the 2016 general election. The next question is, how do I know what the base rent was?
So the base rent is what the tenant was paying on July 21st, 2015. If the tenant moved in after July 21st, 2015, it would be the first rent that they paid. So the actual rent that they paid. If the tenant usually pays rent on July 1st, right, and they paid for the whole 30 days, the rent that they paid, most likely the rent that they paid on July 2015 would be their base rent. So you might want to look at July and August 2015 to see what they're paying, and that'll give you a good idea of what the base rent is. If they moved in after, what was the first rent that they actually paid?
Great, thank you, Magali. The next question is a duplex considered a single dwelling?
No, a duplex, it's two dwelling units on the property. So it's, right, so what is a dwelling unit is a living unit, right? So this isn't like an exact science, but like the idea is like how many kitchens are there, how many entry points, how many bathrooms, bedrooms, is there sleeping facilities, bathroom facilities, eating facilities, entry facilities, I think are some things that a hearing examiner or other staff would consider a unit. So essentially a duplex would have usually two or more entries, two different kitchens, two different points of sleeping facilities, two different restroom facilities. For a duplex, or like if the title is actually a duplex, then that one's very straightforward, but it gets a little bit complicated when you have like additional permits or properties that have been constructed without permission. So that's where it might get a little bit confusing, but if the title of the property is duplex, it's two dwelling units.
Great, thank you. The next question is it possible to get these slides? And the answer to that is yes, they're currently posted on our website at richmondrent.org/workshops. The next question is, what effect does the county ordinance on rental increases have on Richmond?
So, yeah, you can answer it if you want.
Sure. So the county ordinance would only be applicable kind of as a secondary measure, because currently the Richmond order is still applicable to Richmond residents. So there was a question kind of, before the 15th when the Richmond ordinance was set to expire, as to like what would happen if it did lapse. And the answer would be that the county's order would be invoked, and therefore Richmond properties that are subject to rent control would still have a prohibition on rent increases. Now, the county's order had a similar exception for certain types of properties, such as single-family homes and condominiums, that kind of thing. Right now, the county ordinance doesn't have much of an effect because the Richmond order is the main governing document for Richmond residents.
Great, thank you, Palomar. The next question has to do with AB 1482. It reads, my rental property is exempted from AB 1482. Therefore, I need to send the tenants the notice of exemption form AB 1482. Am I correct? May I know if, is there a template or form of notice of exemption from AB 1482 from the Richmond Rent Program?
So the answer is no. AB 1482 is a state law. So the rent program does not enforce the state law at all. We might, give basic information on it, but we will not create any documents or answer any specific questions about enforcement under AB 1482. So I have seen a lot of information or FAQs online, so I would recommend that you research the law, or you would need to contact an attorney.
Also, I was going to add in reference to the first question, if whether or not you're correct that you need to send these tenants this notice. If you look at the law, it actually says that for tenancies that were in existence prior to July 1, 2020, which just passed a couple weeks ago, it's May. You may send them this notice of exemption form, but it's not required. Only if the, first of all, that the property is in fact exempt, and second, that the tenancy started on or after July 1, 2020, does that form need to be included in their lease agreement. But Magali's right, for more specific, requirements and to really kind of dive in depth into the law, you really should look at the law itself. And by the way, AB 1482 is no longer the name. The AB stands for Assembly Bill, so that was prior to its passage. Now it's codified in several separate civil codes. I think it's 1947.12, 1946.2, and there's another one as well. But you can still kind of research AB 1482 and it'll kind of bring you links. And also we have some useful information and a fact sheet on the Richmond Rent Program website about AB 1482.
Yeah, there's a workshop, Palomar, the workshop. So there's also a workshop on AB 1482 that they can get when they get this presentation.
That's right.
Yes, the AB 1482 workshop is posted at richmondrent.org/workshops, and the fact sheet is posted on our resources page. So on the left-hand side of the website, if you click on resources, we have a fact sheet there. Okay, the next question is, when will we know when the COVID rent guidelines are over, related to tenants not being required to pay rent until a year after?
Right, so City Council would need to take action to terminate the law, to change a date, or to give a specific date on when it will occur. The rent program has no power or authority over the emergency order. It's enacted by the Director of Emergency or Emergency Services and will be changed by City Council. With that said, though, the rent program is educating the community on the order, and we maintain our website constantly updated. So you can check our website. You could also follow us on Facebook or Instagram, and we are continuously publishing or updating any of the information, but we don't have a specific date. I don't think anyone has a specific date. It's going to develop as the pandemic develops.
Thank you, Magali. The next question is related to the previous question about the county ordinance. It says the county ordinance has blanks for the sunset dates. Do you have any more information about that?
I don't know. Palomar, I don't know.
Yeah, sure. So that's actually not correct. There is a sunset date for the county, the Contra Costa County's ordinance. They recently, the Contra Costa County Board of Supervisors met, I think either earlier this week or last week, and extended their order until September 30th. So that is the current sunset date for the county's order.
Thank you, Palomar. The next question is, instead of filing an eviction, how do I go about offering cash for keys?
So the rent program actually doesn't counsel on cash for keys, or what is called a buyout agreement. What I will say is that cash for keys or a buyout agreement is considered a voluntary vacancy. If the tenant accepts, you will want to consult with an attorney, make sure that it's in writing. And the idea is that it's not just cause for eviction. So if the tenant does not accept, then you cannot evict them unless you have just cause for eviction. Yeah, that's usually what I say. We don't counsel on it because it's outside of the rent ordinance. The rent board at one time did consider regulations for buyout agreements or cash for keys agreements, but they haven't gone to city council, so they haven't been enacted. Palomar, I don't know if there's anything you want to add.
Yeah, I mean, yeah, Magali's correct that this would be considered what's called a buyout. It's a voluntary settlement agreement where both parties agree to certain terms that, you know, currently Richmond doesn't have any certain regulations or a buyout ordinance. Other jurisdictions such as Berkeley, San Francisco, and I believe Oakland do, and they have minimum requirements for the buyout, not in terms of terms like how much or how much time or anything. That's always up to the parties. But for example, like San Francisco has like a 45-day period where the tenant, or 35-day, I can't remember, where the tenant can actually rescind from the buyout agreement even after they sign it. There are multiple disclosure laws or disclosures that you must make to the tenant prior to them signing the agreement. And there's all kinds of other requirements. But currently Richmond doesn't have that. So yeah, I mean, it's basically up to the parties. But my sole recommendation, if you are considering this, is to just talk to legal counsel and to get everything in writing as well, because these documents are, you know, if you're really trying to do this correctly, you want to do it right. And there have been cases about buyout agreements that I've seen. So you just want to be cautious when you do them. We can't hear you, Paige.
Muted. Thank you both for your answer to that previous question. The next question is, do other Bay Area cities have 4 Richmond program fees? I think what this question is getting at is, do other cities have multiple fees that landlords need to pay? The answer is yes. I'm aware of several other cities that have different fees for rental inspection, for fire inspection, for business license, and for rent control and just cause for eviction policies. The next question is, will you comment on Richmond Order 7420? So that's the order that was just passed by the city manager. Specifically, page 5 near the top, item 1, for non-payment of rent, the tenant is to demonstrate the effect or the impact, I think they mean, of COVID-19. If the tenant does not do that, does it mean there is a means to evict them?
I think that's talking about that the tenant has to notify the owner within 30 days of the rent being due, of their inability to pay rent due to COVID. So in order for the tenant to be protected under that order, they first have to notify the owner of their inability to pay rent in writing within 30 days of the rent being due. Otherwise, I mean, the tenant is exposing themselves to a 3-day notice. I mean, the courts are limited, so I don't know how successful you would be, but that is an option that you can have if the tenant, sometimes I get calls from landlords that are saying, I haven't received a call, I haven't received anything in writing, I don't know what's going on with the tenant, so what can I do? And so in order to be protected from, you know, eviction under that order, tenants do need to notify the owner in writing.
Yeah, that's correct. And the other thing is that it's not so simple. I mean, because even if the tenant doesn't invoke the protections of the most recent iteration of that order, the fact of the matter is that evictions, also called unlawful detainers, are a complicated legal process, especially now because the reality is that let's just say your tenant did not invoke the protections of the order? Well, that means that they cannot claim, that the landlord is prohibited from terminating their tenancy based on non-payment of rent. But that's not the end of the conversation, because then you now have to go file your unlawful detainer in court. Now, the Contra Costa County courts, and in fact, all of the courts in California, the rules have changed regarding unlawful detainers. So back in, I think, April, somewhere around there, the Judicial Council of California, which is the governing body for all California courts, mandated that all these courts change their rules for various types of cases, but one of them was unlawful detainers. And they said, well, the courts are prohibited from issuing summons for an unlawful detainer unless the case is based out of the public health and safety. And so summons is the legal document to inform someone that they're being sued and they need to show up to court. And so even if you go to court and you say, well, my tenant's not paying the rent, I want to evict them, the court is likely going to ask you, well, how is this related to public health and safety? And if you or your attorney can't come up with an answer that the court can accept, then it's likely your case will get dismissed. So if you are considering this, it's highly recommended that you speak to legal counsel.
Great, thank you, Palomar. The next question is, are any of the city council members a landlord? The answer is we don't know or keep that information, so you would need to ask the city council members themselves. The next question is, if I rent to a new tenant if I rent to a new tenant, can that tenant cease paying rent the next month and be protected by the current rent regulations? Also, when can the landlord begin to evict, and will it be a virtual trial or court trial?
Yeah, so I mean, the answer is yes. If you establish tenancy now and the tenant doesn't pay rent, and well, they notify you in writing of their inability to pay rent due to COVID, they would be protected under that order. That order protects residential and commercial tenants. The second question was about evictions, whether they would be virtual or in person. And the answer is, I don't know. You would need to contact the courts. We don't control or manage any of the court's proceedings. I mean, also they're very limited right now, so I don't think they're happening at all.
I think they are, but it's very limited. I know I've talked to a couple lawyers who have gone to court, but things are obviously delayed. They're limiting how many people can be in court, and I think they are. It's not virtual trial. It would be like maybe at most like a telephonic appearance or something like that. That was happening prior to this too, by the way. Attorneys show up telephonically all the time. Yeah, I think Magali's correct that in order to find out the most accurate and up-to-date information, you just need to call the court themselves.
Great, thank you both. The next question is, can I ask a tenant for a security deposit if they do not have one on file?
So if they are not under rent control, you would, yeah, that's a little bit, I would guess I would want more information, because is this kind of like a new owner and then the previous owner didn't give them the security deposit? I mean, in general, under security deposit law, under rent control law, if the landlord can require security deposits, or for example, if my rent is $1,000 and I'm not under rent control and the rent increases to $1,500, then I can require additional security deposit for that difference, right? Because security deposit is 2 times the monthly rate if it's unfurnished and 3 times the monthly rate if it's furnished. For a rent control unit, once the tenancy begins and whatever is collected from the security deposit and the rent, that's it, right? The rent is regulated, the rent is set, which is the security deposit. So you would not be able to ask a rent controlled tenant for additional or for security deposit after the tenancy has been established. It seems like there's more to this question, so I would recommend that you contact a housing counselor if it's not fully answered, because I need additional details. So it doesn't seem like that's the whole question, but for the purpose of time, yeah.
Great, thank you, Magali. The next question is, are invoices sent for each of the different fees charged by different departments of the City of Richmond? Can this be done prior to creating late fees? And the answer to that is yes, invoices are sent from each of the different departments that assess fees to landlords in Richmond. So you should receive your invoice with instructions for how to pay the different fees. In terms of late fees, those late fees are assessed after there's been non-payment or late payment of the fee. So you should receive an initial invoice stating what is owed, and if that amount is not paid within a certain amount of time, then you may become liable to pay the late fees.
One thing that I do want to add to that is, I think in those examples, make sure you call the department and ensure that each department has your correct and current address. Because a lot of the times I'll speak to landlords and they're like, oh, well, I moved, I no longer live there. But it's, how is the city supposed to know that, right? And that's why the enrollment is so important, to make sure that your information is up to date.
Yes, very good point, Magali. And we have contact information for the different departments on our website as well, on the fees page. So if you want to check in with the different departments to make sure they have your updated contact information on file, that would be a great place to look for the different contact information for the various departments. The next question is, if I own a property that is one building but has 2 units, do I pay $217 or double that? And the answer is the fee is assessed per unit. So you would pay $217 per unit. So for 2 units, you would pay double that.
Yeah, well, per rental unit. So both units are being rented out, if both units are being rented out.
Right. The next question is there a way for landlords to know what orders, provisions, laws, etc. that the Richmond Rent Program is discussing or is in the process of passing several months before being announced on the website to allow for more transparency? So this is a great question, and there are ways for community members to be involved in the policymaking process. So the answer is, first, you can always attend the rent board meetings. They're being held virtually right now due to COVID, but you can log on. They're held on Zoom. So just like this webinar, you can log on and observe them, and also submit public comment. The agenda packets have instructions on how to do that. But we recognize that just attending a rent board meeting may not be the most interactive way for community members to be a part of the policymaking process. And so when the board is considering large policies, such as the owner move-in eviction policies and regulations, there have been community workshops held for landlords and tenants and interested community members to participate in. And that's allowed people to get more engaged in the different policies that the rent board is considering and submit their feedback. We've also, as part of that process, we had a survey that we asked folks to fill out. Those regulations for owner move-in haven't been drafted yet. Once they've been drafted, we will post them on our website. It's anticipated months before the rent board considers adopting them. So like we did with many of our other chapters of regulations, they are posted on the website in advance, and listserv messages are sent out to let folks know that there will be, for example, a month-long comment period so that folks can submit their comments and meet with rent program staff to discuss their concerns about the proposed regulations. So there are many ways to get involved. And if you have any questions about specific policies, you're welcome to contact rent program staff by email or phone. And you can also contact specific board members by emailing the rent program and putting attention board members in the subject line. The next question is, are there advocates within the City of Richmond who are working to reduce the complexity of the different city programs affecting rental housing and reduce the expenses of operating and administering these different programs? What would be the path of repealing the rent ordinances? So I can answer this one. Are there advocates within the City of Richmond? I'm not sure if there are specific community advocates who are working on this. I do know that internally, we have had conversations among city staff about how to make this easier for landlords to comply with all the different programs in the city. We've discussed the possibility of having one consolidated bill that goes to landlords. The complexity, however, is that depending on your specific circumstances, you may or may not apply to these different programs. So each program has its own due date, has its own funding cycle, and has its own exemptions. So first, we just need to figure out how to administer a process where, if a fee doesn't apply to one specific property, the invoice can reflect that. But we do recognize that it is a challenge for landlords to be in communication with all the different departments about their fees. And so we are working internally to try to simplify that and have greater communication between departments. In terms of repealing the rent ordinance, since the rent ordinance was passed by City of Richmond voters, it would need to be repealed by City of Richmond voters as well. So it's not something that would happen, by the City Council or the Rent Board. It would have to be go back to the voters during an election cycle. The next question is related to COVID. So she's commenting on a question she asked before. I meant to say, how will we know when the COVID rent guidelines are over? Email, and who will make that decision?
Right, so City Council, and right now, so I would recommend that you read the 4th supplemental order. It's on our website. So essentially, the way that it's written is City Council will need to take action. Right now, the order is pretty much going indefinitely. And the way that it's written is that City Council will need to take action to either terminate the order, to enact an exact date of when the order will be terminated. And I think I said this before, I don't think there's an exact date, right? The idea is how the pandemic is going to develop, right? Like how many people are going to be unemployed and when will we be able to go back? I don't think the word is normal, but essentially function as a regular economy or as a regular labor market. Essentially, the law is a product of this pandemic, and to ensure that people are not homeless, to ensure people are not evicted and pushed out of their shelter.
So I would add that the discussion of the order is on the City Council's agenda for this coming Tuesday. So it is an item that they will take up at their next meeting on Tuesday and discuss whether or not to extend it, repeal it, etc. So you can tune in to the City Council meetings.
One thing that I would also add is that depending on what the City Council does with the Richmond order, the Contra Costa order is still in effect, and that would be in effect until September 30th. And the order is very similar to our current order. So depending on what the City Council does, there will still be the like Pao Palomar has previously said, that's kind of like the second law in place, is that the Contra Costa order, if there is no Richmond order, would be in effect then.
Yes, good point, Magali. Thank you. All right. Our next question is, my Richmond rental property is not under rent control, but it's under eviction control. If I want to increase the rent, is there a standard rent increase notification I have to use from the Richmond Rent Program? Can I use the rent increase notification example downloaded from the internet?
Right. So the rent increase form that's on the website is for rent controlled tenants. So, I mean, you can use it if you want, but the stipulations or the language around it is very specific to rent controlled units. There's a MAR calculator, right, that calculates the rent control. And I think the main page also discusses rent control, and it's a 30-day notice because the assumption is that it's going to be below 10%. So if you're not under rent control and you want to give a rent increase, the only law that you're under or that you would need to follow is Civil Code 827. If it's less than 10% notice or increase, it's a 30-day notice. If it's more than 10%, it's a 90-day notice. One thing that I would like to mention, I think Palomari brought this up before, is that there is a penal code, a criminal penal code, in terms of when there is a health emergency. It's kind of like an anti-gouging measure, and it prohibits, you know, kind of like an increase in prices to an extreme level. And one of the services that is under that order is housing. So if you're thinking of increasing the rent, I think it's by more than 10%, that might be a penal code that you would look into under normal circumstances. If you're not under rent control, you would need to follow Civil Code 827.
Thanks, Magali. The next question is, are single family homes considered partially covered rental units?
So I think single family homes, or that title, kind of does a disservice in terms of like when you're considering the ordinance, because a single family home can be under rent control. So what we like to use is how many dwelling units are on the property. So if there is only one dwelling unit on the property, it would be exempt from rent control and only partially covered. If there is more than one dwelling unit on the property and it's built before February 1st, 1995, then it potentially falls under rent control. Does that answer the question?
If it hasn't answered the question, I would say whoever submitted this is welcome to submit an additional question.
Sorry, I kind of blanked on the question.
Yeah. Okay, the next question
time
is,
check. We got about 8 minutes left. Sorry.
Yes. What if landlord is still paying the mortgage on the rental property and the rent payments are barely paying the mortgage? Then after all the Richmond programs fees and county property tax, the landlord is in debt. I'm not sure I understand what the question is here. So I would say that this person should contact the rent program to speak with a housing counselor. The next question is, what effect does work furlough and COVID have on rent increases that are now due?
So I'm not sure what work for, I mean, are you saying that the tenants are furloughed or something, or they're having some financial impact? I mean, the fact of the matter is that the order still is in effect. And if you've had a rent increase that is quote unquote now due, the order prohibits that. You can't do any rent increases and make them effective during the existence of the order, which, as we said earlier, is not expired. Plus you have the county's order too. And remember that the Richmond order does not say, you know, only if you lose your job, or, you know, only certain things can you claim this protection. It says if the tenant household, not just a single person, but if the household has suffered financial harm, then they can invoke the protect, and they inform the landlord in writing, then they can invoke those protections. I mean, the fact of the matter is that people are being affected financially in all kinds of ways. And it's not just job loss, it's reduced hours. It's the fact that daycare is not possible, so they have to come back and watch their children. Maybe their children became sick, so they have to take off work. I mean, there's all kinds of different ways that a tenant could be potentially financially impacted, and thus they can invoke those protections.
Great, thank you, Palomar. We have a question here also. Where do I go to register as a landlord and pay fees?
So I recommend that you can email the rent program, and we would be happy to forward you all of the links. But the rent program website has a section under, the tab is called enrollment. So if you go to the enrollment page, there's the information for enrollment, and there's also the information for tenancy registration. Once you enroll your property, at that point you would be added to the system if you aren't already, and an invoice will be sent to you. So the most important thing is to enroll, and the invoice would follow.
Okay, we have another question here. If your property is covered by just cause only, does it need to be registered with the Richmond Rent Board?
Yes, so you will need to enroll your property at the minimum. So all rental units in the city of Richmond that are covered by some section of the rent ordinance need to enroll their property and pay the residential rental housing fee.
Okay. Great, thank you, Magali. We have a couple more questions. One of those is, being that the rental housing fee is so excessive per unit, why is it that the landlord cannot add this fee to the rent payments?
Well, I think the main question is that the rent board hasn't allowed it, right? So there has been several policies that have proposed for a pass-through, but the rent board has not approved those for the fee to be passed through. So ultimately the rent board is the main decider of these policies. So there has been proposals for a pass-through, but it hasn't been passed or approved by the rent board.
Yeah, and remember that the tenant's rent is controlled. And if you want to, if you ever need to, or excuse me, if you ever desire to increase the rent besides the AGA, there's a petition process for that. Now, Paige, correct me if I'm wrong, but I believe that the MNOI petitions do have that as a potential reason to ask for a rent increase. Is that right?
Yeah, so I mean, it's a little more complicated so that the landlord can factor in the rental housing fees and all city fees as part of their operating expenses. So what the maintenance of net operating income petition does is it looks at what is the landlord's net operating income in the base year, and it compares it to the current year. And if the landlord has not made a fair return based on the increases in net operating income, then the hearing examiner would permit the landlord to take a rent increase to compensate for that. So I do recommend, based on the fact that the fees have increased this year and that there are city fees, if those are becoming a problem for a landlord who's not able to operate their business, or they find that their expenses are increasing more than their rents are increasing, that is why the maintenance of net operating income petition exists. And so that's available on our website under forms. There are a number of petition forms. One of them is the maintenance of net operating income petition. I strongly encourage that you contact the rent program to speak with an analyst about filling out this petition before you submit it, so that you can make sure that you submit everything that's needed in order to process the petition. We have a couple more questions and a couple more minutes. The next question is, why are there so many different departments for the different various programs? Why is there not only one department for all programs? That's a great question. I think it all stems from the fact that different departments are responsible for administering different programs. So, and certain departments are better able to administer those programs. So the rent program was created to administer the rent ordinance, which deals with rent control and just cause for eviction. The rental inspection program, that's administered by the community services department, because that's where they have building inspectors and code enforcement. So they're the best department to administer that. And the finance department administers the business license tax, which is a function of the finance department to administer those taxes. And the fire department administers the fire prevention services fee. So yes, it's possible that there could be one housing department that houses all of these different fees, but the rent ordinance establishes the rent program as a separate independent agency. And so there are some complications with trying to merge the rent program with the city. And the last question, well, we have two more questions, we can answer them. Second to last question, can the council members bring back to the voters the repeal of the rent ordinance and various Richmond programs? This is a big question. Some programs are passed by local ordinance of the city council, and some were established by the voters. So it depends on how the program was initially established. And in terms of if council members can bring the item back to the voters, I honestly don't know. I think that would be a better question for the city clerk's office. So I would recommend you contact the city clerk's office. And the last question, I saw a Bay Area Legal Aid phone number. This looks like the legal advice line number from the Richmond Rent Program site, but cannot get in touch with them. Just wondering, is Bay Area Legal Aid part of Richmond city departments?
No. So Bay Area Legal Aid is their own legal entity and agency. We do have partnerships with them, so they do provide legal assistance to landlords and tenants, but they are their completely separate entity and agency. I will say that they're probably really busy, as most agencies operating right now are. So their number is on our website. I do know that they are still providing assistance because I have spoken to several of their members and have spoken to people that have worked with them. So I know that they're still providing services, but I would just think they're very busy.
If you'd like to send us an email at rent@ci.richmond.ca.us, we would be happy to forward your email along to our contacts at Bay Area Legal Aid to see if they can assist you that way. So our email address is on the slide before you. So feel free to, for anyone who didn't have their questions answered today or would like to speak further with an analyst, please give us a call, 510-234-RENT, or send us an email at rent@ci.richmond.ca.us. And a lot of materials, including these PowerPoint presentation slides, are available on our website at richmondrent.org. Thank you all so much for attending. We really appreciate your participation, and we hope to see you again at future workshops.
Bye.
Thank you, everybody.